Hi everybody, welcome to John's Briefs. Today, I want to talk here on John's Briefs. I don't have Tim with me here today. Don't worry, he'll be back next week. I just ran out of material with Tim and we couldn't work our schedules out together until such time that I could get this one up for you. We are talking today on John's Briefs. It's fortuitous anyways, because I wanted to talk about this, about kind of the process of using an expert witness and the retention of an expert witness and what their opinion is based on. To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below. So if you've been paying attention, I just finished a trial in the case of Arizona versus John Elliott out of Payson. Thankfully, Mr. Elliott was acquitted on all charges in that trial, and we're very grateful for that. We have a lot more to say about that. I'm going to have Tim come in on some of those things, but I was thinking through kind of some of the things that the prosecutor used to try to keep me out of court, which they're going to do, and some of the ways that I had to act and the ways that I interact with the attorney. And I thought I would give you some of that and understanding of that on John's Briefs today, just so that you understand kind of how the process works. So first and foremost, there are rules of ethics to the use of expert witnesses. And there's Federal Rules of Evidence 702. We talked about that in the Daubert Challenge, right? So go watch the Daubert Challenge video if you haven't watched that. It's here on the channel. I'll put a link in the description. And that makes sure that the evidence that gets used from an expert witness is high quality, right? That they're qualified by their training, background, education, experience, etc. That they use sufficient facts or data for their opinion, that they use sufficient procedures and testing modalities in order to validate their opinion, and that they apply good logic and reasoning to the facts and the data to get through the logic and reasoning to a reliable conclusion, okay? So if you do all those things, you've met a Daubert Challenge, great. Long before that though, you get hired by a lawyer, and I get emails and phone calls from attorneys. Emails, almost always emails, because I don't publish my phone number online. And a lot of times we'll get a contact through our website, through the activeselfprotection.com website. And hey, I've got a case that I'm interested in talking to John about. Will you have him get a hold of me? And they'll leave me a phone number, email address, something. Okay, tell me what you got, counselor. And they'll call me or email me. Hey, I've got a case. When can we talk? Cool, let's talk. I think I've got a self-defense case that I need a use of force expert in, or I think I've got an issue with a firearm that I need a firearms expert for. All right, give me the elevator pitch. Give me your 30 seconds on what the big issues are and what education and help you need for the jury on this case. Then I listen. Okay, now I might say in those cases, I've had consults like those, and we, you don't charge for those. I've had consults where I've told attorneys, yeah, you don't need me. You actually need somebody in this other realm on those. I've had that. I recently had that with a couple of Marine Corps lawyers who I'm getting passed around like a bottle of moonshine at a West Virginia family reunion by the Marine Corps Defense Services right now, because I'm thankfully, hopefully doing a good job for them in a couple of cases. And so those lawyers are talking about me. Cool. And but I got a call from some lawyers, from some other lawyers, had a different case, and they're like, hey, John, we're interested in maybe hiring you for this case. And I said, I don't think I'm your guy. I think you need somebody in this vein. I don't necessarily know somebody in that vein. I would go hunt somebody down in this vein. In that case in particular, they needed somebody much more from a medical bent, from, how long would this take to be fatal and what kind of injuries would this cause? And I'm like, I think you really need somebody more in the medical vein than I can help you with. It's kind of not my lane. But if I say, well, I think that sounds to me like you could have a claim of self-defense. You could have a justified use of force there when, and this sounds like it could be in my lane. But of course, I always say every attorney this. I always say I cannot tell you what my opinion is going to be of the facts until I see them, right? So I can't tell you that I can say that it is a claim of self-defense until I actually see discovery. And so if you'd like me to look at discovery, I can do that. And then they'll talk about that. Okay, I can send you my CV. Your CV is your curriculum vitae. It's think about a curriculum vitae as like a big bougie resume. Okay, so it's like way more than your typical resume. It's like all of your admissions as expert and your formal training and your certifications in things and your background and experience in those, your professional affiliations. And so, your CV is kind of like, this is why I'm qualified to do what I do. It's like a big resume, right? I think mine right now is about 5 pages long. 4 or 5, I don't know. I haven't looked at it. I've looked at it. I just looked at it. I just had to update it, in fact, but I forget exactly how long it is. Anyhow, I'll send them my CV. I'll send them my current rate sheet, and then they will oftentimes email me back or call me and say, yep, we're interested in hiring you. Okay, cool. So then what I require is a 10-hour retainer. And so that 10 hours tells me they've got a little skin in the game, because one of the things that as an expert you have to do is the American Bar Association has an ethical standard for the use of experts. It's not actually in like the CFRs or actually in the statutory law, but the ABA has some pretty good standards for the use of experts here. And one of the major standards for the use of experts is an expert can't be paid on contingency. So in other words, I can't say, oh, okay, I'll give you an opinion, and if you win, you pay me this, but if you don't, then you don't pay me, or you pay me less. Because then I get to become a partisan, and I get real invested in helping you win. Whereas my real role as an expert is an educator. And so I say, nope, if you want to pay my hourly rate, then I will look through discovery and I will give you my opinion once I've looked through discovery. If that opinion is conducive to your theories of the case, then maybe we can talk about going forward. If it's not, then I give you education as to why, where your challenges are, where the sticking points are in your case. And then I've done the education for you, and you can use that for whatever you like. You probably won't hire me for anything more. Okay, they send me a retainer. It's 2025, and I don't mind telling folks that my current retainer is 10 hours. My right now, this moment billing rate is $550 an hour. So it's a $5,500 retainer. Our incredible accountant, bookkeeper, Jamie, sends them an email with an invoice. They pay the invoice. Cool, I get started on work. Now, then what do I have to do? I have to look over discovery. And what discovery is, I'm often hired by the criminal defense attorneys. That's very typical for me. I've had a couple of civil cases, so either the plaintiff or the defendant in that case. And I'm working one case for the prosecution right now. So again, I'm an educator. I'll educate however you want me to educate. So when I say to them, I go, look, I need all of the discovery you have. Now, I go Ron Swanson on them here, right? So this Parks and Rec reference where, you remember that old thing where Ron was like, just bring me all the bacon and eggs you have. Wait, I'm worried that you heard me say, bring me a lot of bacon and eggs. What I said was, bring me all the bacon and eggs you have. And then the guy goes, and then brings him a big pile of bacon and eggs. I tell him, listen, I want all of discovery. Don't give me partial discovery and expect a full and fair opinion from me. I need all of discovery to look it over. Now, if you say, hey, there's plenty of this discovery that's not really pertinent to anything that you're doing, and I want you to focus in these areas, great, but I want the ability to look through anything that I think is important, so I want full discovery. I've had attorneys, I had a couple of times where I had an attorney be like, well, John, I just want you to look over this particular portion of discovery and give me your opinion based only on this. My answer is no. I do know experts who will do that. And they might say, okay, well, just looking at this and just seeing this particular part, this is my opinion. I don't feel like that meets the standard of me giving a full and fair opinion. It's a very partial opinion. So I say, nope, I want all of discovery. Well, I really want an opinion just based on this stuff. I'm sorry, I'm unwilling to do that, so I won't send you a retainer request and we won't work together. They send me that though, and they go, okay, here's all of discovery. What that normally happens, it's kind of weird because discovery comes my way a couple of ways. I have literally, there are still some really old school lawyers who will send me a thumb drive, okay? I've had one lawyer send me a file, like a physical file. All right, cool, man. It's like 1996. Usually today, in government cases, they have their own system for delivering documents, which is basically like a secure server system through their websites. And a lot of attorneys these days, they either have a Google Drive, a Dropbox, something akin to that, they're like, yeah, man, I'll send it all to you. And they send me a link basically, or they add my Dropbox or my Google Drive, my Google account to their drive. And then that way I can access it. Okay, cool. Then I pull that into my stuff and now I've got a copy of it. And then I look it all over and I am looking for all the things that are important to me. I will often go back to them and to the attorney and ask for more and say, is there anything on this? Do you know if there's anything on this? Have you asked this particular question? Like in the Elliott case, there was a particular witness who had said that she had seen something, but that she wasn't wearing her glasses. And so, but she didn't really need them. And I said, well, have we had an eye exam for that witness so that we know how badly she did or didn't need glasses? Because that could be an important part. She had this statement to make. This is part of my testimony. She was a certain distance away. She had all these things. We're going to talk about those in future videos on the Elliott case. So then I look it all over. And then once I've looked everything over, once I've listened to watched all the badge cams, listened to all the interviews, taken careful notes on those, gotten everything kind of in order. And I'll tell you, a lot of times that takes me more than the 10-hour retainer. And usually we square up at the very end after that. So the 10 hours says they've got some skin in the game, and then we square up with everything else at the end. Because I've got to listen to interviews and take notes on them. So if it's an hour-long interview, it might take me 90 minutes to listen to because I have to stop, take notes, back up, make sure that I, transcribed it correctly, all those things. Badge cams take forever, reading reports, you got to go back and highlight, make sure that those are okay, that you've got a good picture, that you've got, what you see here in terms of the issues of the use of force. Identifying what are the human performance factors in perception, in decision-making, in, the speed of assault, looking at the diagrams and the pictures of the place of the incident. Can we access that place of the incident? Do we have pictures of it? Do we know exactly how those things went? And give me the crime scene photos. I read medical examiner reports and get to see stuff that for most people gross you out, kind of gross me out sometimes. If you've seen an actual medical exam of somebody who's been shot to death, it's gross. And all right, once we see all that, then I schedule a call with the attorney. Hey, attorney, here's my opinion. My opinion is, and I'll tell an attorney very clearly, hey, here's where I think your problems are. Here's where the stink is on your case. I think these are the areas that are most liable to be attacked. Here's the areas that I think are strong. I think at the end of the day, this was or was not a justified use of deadly force. I have said, I don't think that the prosecution can prove beyond a reasonable doubt that this was a crime. And I don't think it was a great idea, but I don't necessarily think that this was provable as a crime. I have said that. Now, I have never said that because I wanted to get somebody that I thought was a really bad person off on a crime, but rather to just say, I see here that there's some stink and this could look either way, but I don't think beyond a reasonable doubt that can be proven as a crime, which in our system should mean that he or she is acquitted of that crime. Okay, cool. Then I asked the attorney, the next thing is, would you like me to write that all up as a report? And I always tell them before we even get started, I would strongly encourage an expert report. You don't have to write an expert report. You don't have to. However, what it does is A, it lets me organize. B, for me, it lets me do what I am very best at. What I am, my real strengths as an expert witness are twofold. Number one is research writing and writing reports. And number two is testifying in front of a jury. Those are the two things that I do really, really well. The expert report writing is because, guys, I have a master's of divinity and biblical communication and half of a doctorate of ministry and taught research writing at the graduate school level for about 5 years. And so research writing comes to me. I have done a ton of research writing, and that's what an expert report is if you're doing it right. It is a solidly researched, solidly written research report, paper. And I'm really good at those. I got A's in seminary on those, okay? Because I can research well, I can cite sources well, I can make an argument well. And so I go, first of all, let me do that. Because if sometimes, and I've had this happen in cases, we can disclose that, because once I write a report, then that is discoverable by the other side. So that gets submitted to the court, submitted to the other side. Usually, again, if I'm usually working for the defense, working in this case, it'd be sent to the prosecution. And then the prosecution can read it over. They certainly will. Often the prosecutor will want to do a pretrial interview with me at that point, because they're going to want to try to poke holes in what I do and try to kind of figure out how they can minimize the impact. But I have had times where the prosecutors read that and went, "Ooh, boy, that's some big gaping holes in my case," and offered the defendant a much better plea afterwards. And so when we get that, I've even had a couple of cases where the prosecutor's being real serious about serious charges, and then here's an expert report that says otherwise, done a pretrial interview, well, tell me about this and tell me about that, and what about those things? Yeah, I don't think that's the case, counselor, and I'm not trying to give you a hard time. I don't see you as the enemy. I'm just trying to educate here. And then they offered an acceptable plea bargain, an acceptable plea agreement, and the client was able to stay out of court and plead to a misdemeanor and keep their rights and move on with their life without the risk of a trial. And so wonderful, even though that costs me a bunch of money, because if we go to court, I get paid more for it. I'd much rather, for the client's sake, that it go from there, okay? So that full, fair, and unbiased opinion, that's what the American Bar Association says. John, as an expert witness, you have to give a full, fair, and unbiased opinion in your lane based on your training, background, education, and experience. So that's what we do. We write it all up. We send it to them. Like I say, then usually we will then help the attorney who hired me to answer the Daubert challenge that is absolutely coming. It's almost 100%. I just expect them at this point. I've got a news story I'll talk to you about another day of an expert that was in a non-defense related field. I read an article about her, who's like, I mean, as expert gets, with incredible, a CV that's so serious that you're like, my gosh, it's probably maybe one of the world's leading experts in this field, testifying about that field in a case that directly relates to that field. And the other side filed a Daubert challenge. Oh, this is just, advocacy masquerading as expertise. And I'm like, I've heard those words. That's great. I feel so much better about me. It's not about me. They always do this. So we help them craft an answer to the Daubert challenge. Always have to be handcrafted because the challenge itself will be handcrafted. And then to prepare, they're obviously also then, if I was the attorney on the other side, the number one way you can keep an expert from hurting your case is to get them excluded completely. We don't need to talk about an expert in this case. This is the province. This is the province of the jury. He's invading the province of the jury. So we're very careful to try not to do that. Most states do allow, under the current federal rules of evidence, the 702. Again, it was amended in December 2024, or I'm sorry, December 2023. It was amended. And we can give opinion. We can give an opinion to the ultimate fact. And in a lot of states, I'm allowed to do that. Some states still balk at that, still don't love it. And that's okay. I always say I don't want to invade the province of the jury anyways. I want to leave that to them. We try not to talk about a reasonable person and this is reasonable or not. Jury gets to decide what's reasonable. So we answer the Daubert challenge. We prep for them to try to narrow the scope of my testimony. The second thing they would do, rather than keeping me out completely, is try to say, well, but you can't talk about this because that's the province of the jury. That's the province of the judge. You don't get to talk about any of those things. We just, will allow you to talk about this very narrow thing. And so then we help the other side to kind of, okay, so this is why that's important. And again, to help them to apply that with those to this. Now, sometimes the other side's able to narrow that testimony, but the lawyer still has all that stuff. So they get to take the tests and data and testimony that I've given, apply it with the logic and the law in their opening and closing statements and in their questioning and those things to achieve the same ends. And then we go testify in court if it comes to that. Now, it's very rare that we actually get to court, right? Because most of these cases are pretty cut and dry. They'll normally, like 96% of criminal cases in America don't go to trial. They end up in a plea agreement of some kind if charges are filed. And so then we go, okay, great, and if they get a little snarky and they get a little saucy, then sometimes that's when I get involved. I always say get an expert involved early rather than late too, because it can help you craft messaging and help you craft an understanding. So then that way you're not scrambling at the very end. But it's rare we get to court on these things, but when we do, they're usually kind of a big deal and a lot is at stake. We're talking about significant felonies here, 10, 15, 20 years, life in prison at times, even the death penalty in rare cases. I've never worked a death penalty case. I've worked a life in prison case. And so, prepping for court and making sure that everyone is there. Now, an interesting issue, there have been times in the Elliott case that I just did, that I did not talk to the defendant until we got to trial. I didn't meet him. I had no contact with him until we got to trial. And in this last case, the prosecutor was like, well, at my pretrial interview, well, did you not interview the defendant? Nope, sure haven't. Well, don't you feel like that's an important piece of information? And why would your opinion be full and fair if doesn't even include an interview with the defendant? Now, of course, why do they want me to interview the defendant? Because it gives them some more information, because if I interviewed the defendant, that would have to be recorded. We would have to have notes of that, or at the very least, probably they would expect it to be, video or audio recorded. And that's a source for them to mine for information and for potentially to pigeonhole the defendant into a particular spot. In that particular case, in the case of John Elliott, he had given a statement to police after they had Mirandized him. So they read him his Miranda rights after the shooting that had occurred. And he then the detective said, so tell me what happened. And for the next 25 minutes or so, he interviewed John, and John gave him statements on the record on badge cam. So I said I didn't need to interview Mr. Elliott because we had a statement from Mr. Elliott afterwards, and it was a good statement. It was, we'll talk about it later. We'll talk about it later, but it was a good statement from him. A lot of problems with the way that it was handled. But because of that, I said I didn't need to, and I didn't want to risk the bias of having a personal relationship with the defendant. I just wanted to look over all the evidence that was available from an unbiased third-party opinion. And so I didn't actually meet him. I met Mr. Elliott on the day that I testified. I was not in court the other days. Every day that I'm in court, I'm not working my regular job, so then my daily rate applies for trial. And so I said, I'll be there. I can help you with messaging. I can help you by taking notes and make sure that it's good for cross-examination. I can do all those things for you. And of course, then I hear all the testimony and I can talk about that when I'm on the stand. But it costs money. And oh man, we can't do that in this case. No problem. So I showed up the day of my testimony and I literally met the defendant about 20 minutes before I went on the stand. Didn't even talk to him, did not talk to him one bit about the case. Shook his hand. Hi, Mr. Elliott. My name is John Correa, and I'm really sorry that I got to meet you. I'm really sorry that we're in this position. Got to meet his wife, same thing. Then she said, man, John, I'm so glad you're here. Thank you so much for being here. And I was like, I'm really sorry to meet you, actually, and I'm really sorry I'm here because I didn't think this one should even be here. But we'll go testify then, and then the chips fall where they may. So that's kind of the process of an expert and how that all works. Once everything is done, then I keep track. I've kept track the whole time, in this case, how many hours that it took me to do everything. And I have a thing where I know, you kind of get this idea that lawyers, they bill by, and they do bill by the 10th of an hour every 6 minutes. They're writing down a 10th so that they can bill. And those firms, there are firms that do that. I don't do that. Honestly, I tell folks all the time, listen, I'm going to keep track so then that way I can give you a general idea. I always, at the end of things, I'm like, okay, so, this actually took me, about 11 and a half hours to do. I'm going to bill 10 on that. And this took me another 5 hours to do. I'm going to bill those 5. This took me, 7.5 hours to do. We'll bill 5 more on that. And at the end of things, we'll add those up. Okay, so there is a grand total of 32.7 hours, but I'm going to give you a discount on that and only bill you 25. Why do I do that? I mean, at the end of things, it's because, okay, was I always 100% as productive as I could have been, just dead focused on this stuff? No, sometimes one of my kids comes in the office and needs something, or I work on it for 45 minutes and then I got to go do something else. And I only have a little bit of time during the day because I have a full-time job. And so, you go, okay, I want to adjust to that. And in this last case in particular, there's a 75-year-old man paying the bill, 77-year-old man and his wife. They're retirees. You know what I mean? It's like, okay, how much of his, and don't get me wrong, I'm worth my money, but at the same time, this is a retiree, for goodness sakes. I don't want to bankrupt him. So that's what we end up. They send it. They pay us. We wish each other well, and then if they need me again, they call me later. So that's where an expert witness is. That's what we do. That's how we operate. Give me all the discovery. I'm going to look it over, give you a full, fair, and unbiased opinion. It has to be an independent opinion. I'm excited about an independent opinion. I will tell you if your baby is ugly or your mom is fat. That's my job. And then we put it all together, hopefully in a report. That's the best way to do it. And then testify if we need to. That is what an expert witness does to you. I don't know that I said all that together. I think looking it over from what I sent to our accountant, I think the total cost for my services for that last one in John Elliott's case was, I think it was a little over $16,000 is what we ended up billing complete. Like 16.8 is what I think it was. And I know some people are going to be like, man, that's just a crazy amount of money. But I've got 10 employees to pay at Active Self-Protection. And when I take time away from doing the stuff like making this content, making the main channel content, I'm not teaching classes this year, so I'm not out making money doing that. I got to pay everybody. So somebody's got to pay that. If you want me to take time away from that to help you, I can, but I got to be able to be paid to do so. I don't think Mr. Elliott regrets it because it really helped him in his case. Anyhow, hope that's great for you. We'll have Tim back next week. God bless you, everybody.